in thinking about the opening statements for both sides, various thoughts go through my head about how I want to present it to you. And just generally speaking, I feel strongly that for opening statements, some of the things that you don't want to do are some of the things that you hear done in opening statements all the time. So, for example, when you're doing an opening statement, rule number one, no cliches. What do I mean by that? How often do you hear a lawyer get up and say, ladies and gentlemen, an opening statement is just like the table of contents of a book. And here are the table of contents, and here's what we're going to do. Or you'll hear lawyers get up and say, an opening statement is just like a roadmap, and we're going to give you, forget about that. No cliches, no opening statement can grab the attention of the people that are listening to it when you use those sorts of cliches. Another thing about opening statements that I think is important is when you're doing an opening statement, I can never understand why a lawyer will say out loud that an opening is not evidence. Why does a lawyer do that? Lawyers do that all the time. The judge will instruct them that it's not evidence, but you want the jury to believe what is coming out of your mouth is in fact evidence, and is in fact the fact. And so I don't understand why it is that, that people do that. And another very important thing, and when it gets to this fact pattern, you'll see how important it is, and that is, don't make a promise in the opening statement that you cannot keep. Don't overpromise, don't over-exaggerate to the jury something that you know you're not going to be able to prove. Because for summations, one of the most powerful things a lawyer can use is the opening statement of their adversary, in which their adversary promised certain things and did not deliver. And by the way, for a plaintiff who gets to speak last to the jury with a summation, I can really do a lot of damage with a transcript from a defense attorney who promised certain things and never delivered. And so I think it's important for you to remember that. Combined with that, something that's very important is, in your opening, make sure that you deal with your weaknesses. And so what does that mean? In this particular fact pattern, there is a plaintiff by the name of Ted Stryker who has certain weaknesses in this case, and I'm going to deal with those. But one of the weaknesses is that his co-employee, there's a sworn deposition testimony from Murdoch, the employee, who appears to be a stellar person and by way of his background, that says, I told him not to enter this room. That's what I told him. And that's a weakness in the plaintiff's case, because it's really just going to be his word against this co-employee who's not a party to the case. In this fact pattern, ladies and gentlemen, Zucker Construction is not a party because there is no grave injury. So deal with your weaknesses. There's another weakness that Ted Stryker has, and Ted's other weakness is that he had been convicted of a felony many, many years ago, but it was a felony, and he went to jail. And that's something that has to be dealt with as well. And so I could speak to you about opening statements for a long time, but I just don't have enough time to do that. So what I'd like to do is get right into the opening statements in this case. And I will first do the opening for the plaintiff as counsel for Ted Stryker. May you please the court. Ladies and gentlemen, there is one consideration, and one consideration only, which is the most important thing that must take place at each and every construction site in this city and in this state of New York. And that is the absolute protection of the workers at that site. The workers, ladies and gentlemen, who have to climb tall ladders and scaffolds, who have to carry material up and down, who risk their lives on a daily basis to build the buildings that each and every one of us live in and work in and take for granted. And I told you all in jury selection that we have brought this case under a very specific provision of New York law. What I told you was that we have brought this case under a provision of New York State's labor law. Specifically, and you're going to hear about this section of the law, Labor Law Section 240. And ladies and gentlemen, we have brought this case under that section because our legislature has sought fit, by virtue of these laws, to protect workers who are injured at a construction site, like the one in this case, from objects that can fall and from safety devices like scaffolds, which are inadequate under the circumstances. Now, in this case, ladies and gentlemen, the evidence will show that the owner of the building is a large, publicly traded real estate company by the name of Midtown Properties. And they hired, for this particular case, a general contractor by the name of Abrams. And they, too, are a large general contractor, and they were putting up this building at 80 East 59th Street. And the evidence in this case, ladies and gentlemen, will show that on this day, April 26th of 2009, the owner and the general contractor failed in their responsibility to the worker, to my client, Ted Stryker, and that the owner and the general contractor violated those special provisions of the law, Labor Law Section 240. The evidence will also show, ladies and gentlemen, that those violations were the proximate cause of horrific injuries to an otherwise healthy, hard-working, 46-year-old man, my client, Ted Stryker, who was sitting here in the first row with his wife. The evidence will show, ladies and gentlemen, that Ted was a union carpenter, and that Ted had been working on various construction sites for over 25 years. The evidence will show that Ted had never had an accident at any construction site. And the evidence in this case, ladies and gentlemen, will show that Ted was what is called a framer. And for those of you who are unfamiliar with that particular trade, framers are the people who do carpentry type work, mostly, as it was in this case, around windows and doors. And that was Ted's job. He worked for a company called Zucker Construction. And his job at this particular site was to frame the windows and frame the doors. And here's what happens on April 26th of 2009. Ted is working on the 5th floor of this skyscraper. And the floor for the most part was under construction. Parts of the floor at different phases. But at this particular accident location, what was going on was that the workers were they were framing a window. And in order to frame the window, which was 14 feet above the ground, they needed a scaffold. Did they bring one of those metal scaffolds to the scene that you've all seen at construction sites all over New York? No. Did they bring one of those Baker scaffolds, the ones that can roll around from place to place and lock the wheels, and you can go up and be on it all day long and do as much work as you need? No. What did they do? Well, these workers designed their own scaffold. One that has never been designed before. Here's what they do. Imagine, if you will, that this piece of vinyl up here, the fan-looking vinyl above the mirrors, imagine that that is where they're going to frame the window. And you see both edges of the mirrors? Imagine that there are two doors that are 12 foot high. And so, what they do is, they take two pieces of plywood and they make swinging doors to enter through this particular doorway. And on top of these swinging doors, they put a plank. So they could stand on the plank and get to the vinyl, to get to that window. Now, do they just put a plank? No. They put the plank on top of the doors, and on top of the plank, their version, their idea of securing that plank is to put two cinder blocks. And that's what the owner and general contractor allowed to happen at their construction site. So what happened to Ted? Well, just after lunch, Ted is ordered by his foreman to go to another part of the building and to bring to this part of the building some wood that would be needed for the work. So of course, Ted, obligated to follow his boss's directions, does exactly that. And he grabs several 2x4s in his right arm, and he grabs several 2x4s in his left arm, and he is on his way to deliver the wood. And as he approaches, and the width, ladies and gentlemen, is very similar to the width of these mirrors. As he approaches this doorway, he bumps into one of the doors. And what happens next? Like a house of cards, his shoulder touches the door. The door moves. When the door moves, the plank comes crashing down and hits Ted in the head, causing him to go immediately unconscious. This makeshift scaffold, ladies and gentlemen, under New York's labor law, was, the evidence will show, absolutely not a proper or appropriate safety device. Likewise, the evidence in this case will show you that the doors, which were not in any manner, shape, or form secured, they were free doors, allowed to open and close, that the failure to properly secure those doors, which would have, of course, secured the plank above, made that scaffold an improper piece of safety equipment. Not reasonable under any circumstances. And now, ladies and gentlemen, let me just digress for a minute, and I want to talk to you about some of the witnesses that you're going to hear from. You're going to hear from a guy who's going to come to this courtroom, call by my adversary, a gentleman by the name of Mr. Murdoch. And Murdoch was a co-worker. He's the genius that built the scaffold. He's the guy who came up with the evolution of scaffolding. 2 doors, not secured, plank on top, 2 cinder blocks. And what's Murdoch going to tell you? What do you think he's going to tell you? He's going to tell you that this accident was Ted's fault. Because when Ted came to the door, I told Ted, don't come in. Well, ladies and gentlemen, I will have my opportunity to cross-examine Mr. Murdoch. And I ask you that when I do so, to please bear in mind that the evidence in this case will show you he's the guy who built the scaffold. And remember how we talked in jury selection about using your own good common sense when you evaluate the credibility of witnesses? Well, do that in this case. Use your own good common sense and figure out whether or not the guy who built this thing would have a reason to tell you that it wasn't his fault, but rather that it was someone else's. Now, in addition to Mr. Murdoch, and in addition to Mr. Stryker, you will also hear from Christopher Sally. Christopher Sally will be called as an adverse witness. Christopher Sally will be a witness called by the plaintiff, by Mr. Stryker, by me, and he will be cross-examined. And when he testifies, remember a few things. He is working for the owner and general contractor. The evidence will show you, ladies and gentlemen, that Mr. Sally is the so-called site safety inspector, responsible for making sure that the site was safe. And while Mr. Sally is being cross-examined, I ask you to pay careful attention to when he is asked about whether or not, in his own experience, this is a proper scaffold. And I ask you to listen carefully to when he is questioned about whether or not this was an adequate scaffold with doors that were unsecured. Now, I have the benefit of having taken his deposition. And so I know what he's going to say with regard to that issue. Mr. Sally will be forced to admit to you that those doors were not properly secured. And so, ladies and gentlemen, in this particular case, as a result of the violations of the labor law by the owner and the general contractor, some very serious injuries occurred. And it's my job as Mr. Stryker's attorney to present to you the evidence in that regard. And what the evidence will show you is that this otherwise healthy, strong, hard-working man was seriously injured because when the board fell, remember I told you a few moments ago, he immediately became unconscious? But he was rushed to the hospital, to Columbia Presbyterian, where he remained unconscious for a period of time. And they took a CAT scan. We were all familiar with the general knowledge of a CAT scan. And they took it of his brain. And immediately what they saw was that Ted sustained what is called a subdural hematoma, and that his brain was bleeding. But as you know, the brain is within our skull. And when the brain bleeds within our skull, there is no place for the blood to go. It's not as though somebody will be injured on their arm or their leg, on another part of their body, where the skin could expand when the internal organs are injured. So it's not as though you're punched in the arm, you get a black and blue, and the skin can expand. When the brain bleeds, there's nowhere for the blood to go. And so if the blood is not immediately evacuated, the brain will shift and herniate. And when the brain shifts and herniates, that results in catastrophic consequences. So in this case, the physicians recognized that he had this severe injury, immediately took him to the operating room. And they performed what is called a craniotomy. And a craniotomy, ladies and gentlemen, is a procedure which you will hear about from the actual surgeon who performed it. And the surgeon will tell you that to prepare Mr. Stryker for this, they had to shave part of his head, cut a flap open of his skin, and then they actually take a drill. And they drill out part of his skull, and they make what is called a skull flap. And they then suction out the bleed, and they try to get out as much of the blood as they possibly can. They put the skull back in, they suture his head back up, and then Mr. Stryker was hospitalized for a period of 10 days. 4 of those days, with his wife constantly and his children constantly at his bedside, 4 of those days were spent in the intensive care unit. And let me tell you what happened when Mr. Stryker was in the intensive care unit. While in the intensive care unit, he had a seizure. But it wasn't just a regular or ordinary type seizure. This seizure was what is called a grand mal seizure. Some of you may have experience with these kinds of seizures. Some of you may have seen it, either live or on video or somewhere else. But it's essentially where the first reaction is this tense reaction, where the muscles tighten, and then the second reaction is the vibration, the shaking action. And all the while, he was unconscious during the course of that seizure. Clearly, this was a big deal. And he remained in the ICU, and the doctors prescribed for him medication, which Ted is required to take for the remainder of his life to control this seizure disorder. And ladies and gentlemen, you will meet Ted. You will hear from Ted. He will tell you, he's not the kind of guy who just sits at home. He has tried to go back to work. His doctors will not allow him to work in the construction industry any longer because he still suffers from some of the residual effects of the brain injury. And by that I mean, he still has some short-term memory loss and some other neuropsychological injuries which you'll hear about from the physicians in this case. But Ted didn't just sit back and do nothing. First thing he did was, about a year after this accident, he went and he got a job as a taxi driver. And he drove the taxi, but unfortunately, as a result of him having a seizure, Ted had an accident with the taxi and lost his driving privileges because the accident was related to the seizure. And yes, ladies and gentlemen, you'll hear Ted be cross-examined about the fact that he had this seizure because he hadn't been on his full dose of medication. And that's true. Why wasn't he on a full dose of medication? Because Ted does not want to be beholden to this medication for the rest of his life. So he tried to reduce the dose of what he had to take, but obviously he failed in that. And he is sentenced to having to be on a full dose of this medication for the rest of his life. So after he lost the taxi job, what happened? Ted went on and he got a job as a doorman. And Ted will testify that the headaches from this injury were too much. he couldn't stand, he couldn't perform his job, and eventually he had to leave that job after just a short period of time. The evidence will also show you, ladies and gentlemen, that with regard to his working, and by the way, before this accident, I told you he was a member of the Carpenters Union, and he received fabulous fringe benefits. Some say that one of the reasons construction workers go to work is not just for the salary, but for the fabulous fringe benefits that they receive. Health insurance for he and his entire family, pension and welfare fund contributions. On top of that, Ted was a hard worker and did make about $75,000 a year. You will hear that he tried to get a third job. You'll see he's heroic in his efforts to go back to work. The third job was a job as a security guard, where maybe he could just sit as opposed to standing all day running in and out of a building. And this was supposed to be a job as a security guard. But you know what? Unfortunately for Ted, and you'll hear him, he's going to tell you about it, 28 years ago, when he was a kid, he served a year in jail. And he served a year in jail because he was convicted of sports gambling. And you'll hear him testify to you that he was doing the best he could as an 18-year-old, without a father, with a bunch of brothers and a mother, and he was doing everything he could to contribute to his family. But that conviction 28 years ago came back to haunt Ted, and he was not able to get the job as a security guard. Now, ladies and gentlemen, you're going to hear the evidence in this case, as I just highlighted it for you. You are going to hear, and you are going to see diagrams, and hear vividly explained to you how this worksite contained this Mickey Mouse house of cards makeshift scaffold. And at the conclusion of this case, ladies and gentlemen, consistent with the oath that you took as jurors and the promise that each and every one of you made to me during jury selection, I will stand back up here and I will ask you to render a verdict that is 100% justice for Mr. Stryker and his family. Thank you very much. So now I'm going to give you the defense version of this opening statement. May it please the court, Your Honor, counsel, ladies and gentlemen of the jury. There is one man responsible for this accident. There is one person entirely at fault for the happening of this accident. And ladies and gentlemen, there is one sole proximate cause of the accident and the injuries in this case. And that, ladies and gentlemen, is the plaintiff himself, Ted Stryker. Mr. Stryker is before you because he refuses to take responsibility for his own actions. And the evidence in this case, ladies and gentlemen, will show that it was his actions, and entirely his actions, which caused this unfortunate accident and the injuries that he sustained. The evidence will show, ladies and gentlemen, that my clients, Midtown and Abrams, are reliable and reputable owners and general contractors who have built some of the most beautiful, some of the largest, some of the most well-constructed buildings in the city of New York. The evidence will show, ladies and gentlemen, that they were so concerned about the safety on this site that they went out and they brought in a site safety foreman, somebody with decades of experience And you will hear from the site safety foreman, Mr. Sally. And I want you also to listen carefully to that evidence. Because when Mr. Sally testifies, ladies and gentlemen, he will tell you that under these circumstances, at this site, on this day, this was a perfectly adequate scaffold. Perfectly adequate. The evidence will show you in this case, ladies and gentlemen, that Mr. Stryker himself, he worked for Zucker. He worked for the framing contractor. He worked for and with the very people that put up this scaffold. Mr. Stryker was on the scene of this accident on that very day and was aware of this scaffold. He was aware of the doors with the plank and the cinder blocks. Perfectly reasonable. It worked well under the circumstances for the workers who were on the scaffold. And it wasn't until Mr. Stryker, coming down the hallway, looking, I don't know where, because if he were looking where he was going, he couldn't have bumped into the doors, which caused the entire device to break and fall. And the evidence will show you, ladies and gentlemen, it was a long hallway until he got to those doors. What was Mr. Stryker looking at? Why wasn't he focused? The width of the opening was about the width of the mirrors. Plenty of room for him to go through. Had he been looking at what was open and obvious, he would have walked straight through the middle, and none of us would be here today. Ladies and gentlemen, he bumped the scaffold. He knocked over the scaffold. And you know, you're going to hear from Mr. Murdoch, as you just heard in opening statements by that plaintiff's attorney. And Mr. Murdoch is going to testify. And let me just tell you a little bit about Mr. Murdoch. He is a retired detective from the NYPD, a decorated police officer who went back and had a second job as a carpenter. And he, ladies and gentlemen, will come and tell you that before Mr. Stryker ever entered the room, Murdoch told him, "Wait a second, Ted, wait." But what does Ted do? He attempts to enter the room anyway. He goes right past Murdoch, hits his shoulder, and knocks the thing over, and knocks it down. And ladies and gentlemen, you'll have to evaluate the credibility of Mr. Murdoch and what there is for him to gain versus these enormous money dollar claims that Mr. Stryker is making. Because if you believe Mr. Murdoch, the case is over, isn't it? But you don't even need to believe Mr. Murdoch because we know the rest of the facts are true. That it was Stryker himself who didn't see what there was to be seen. That it was Stryker himself who bumps into the scaffold. And Stryker himself who causes this entire accident. And so, ladies and gentlemen, this case is about the failure of Mr. Stryker to take responsibility for his own actions. And isn't that sort of the world that we live in these days, where people fail to take the responsibility for their own actions and attempt to foist and cast blame on others? Well, we're not going to take that. And that's why we're here, and that's why we are defending Midtown and Abrams. And at the conclusion of the case, ladies and gentlemen, the evidence will show you that Midtown and Abrams did not violate any labor law. Midtown and Abrams were good. Midtown and Abrams perform their job functions in accordance with all the law. And I want to talk to you just for a moment about the damages in this case. And by that I mean these claims of injury. But I want to say to you that by no stretch of the imagination, do we in any manner, shape, or form believe that Mr. Stryker is entitled to damages. And that you, ladies and gentlemen, will never even reach that issue. But let me just talk to you a little bit about those damages. And I want to start out by telling you, yes, we acknowledge Mr. Stryker was unconscious at the scene. We acknowledge that he was taken to the hospital. And we acknowledge that he had a subdural hematoma and surgery with regard to the subdural hematoma. Clearly, he also had a seizure in the hospital, and clearly his seizures are completely controlled when he takes his medicine. The evidence will show you in this case, however, ladies and gentlemen, that this 46-year-old man is fine. He has recovered well from his injuries. He's not working. Why? He gets a job as a cab driver and decides on his own not to take his medication and crashes the car, loses his license. Who does Ted want to blame for that? Oh, not my fault. Let's blame somebody else, just like we're going to do for the course of this accident. In addition, he then gets a job as a doorman. And the people in the building, they like him. But Ted says, my headaches are too bad. Who here hasn't had a headache when they've been at work? He takes over-the-counter medication when he gets a headache. The evidence will show you, he's never asked for heavier headache-type medication. He could have gotten headache medication had he wanted to, but he doesn't work as a doorman, and not working as a doorman, who does Ted blame? Not me. Not me. That's somebody else's fault too. And then he tries to get a job as a security guard. And yes, ladies and gentlemen, this man was convicted not of a crime, but of a felony. He didn't plead guilty. He was convicted by a jury and sentenced and spent a year in the federal penitentiary. And yes, did that come back up 28 years later? Yes, it did. And should a man who has a felony conviction on his record and spend a year in jail, should that man be a security guard? Well, not according to the security company he was trying to work for. And so, ladies and gentlemen, the evidence will show that this man can work, can get a job, if he wanted to. And so, ladies and gentlemen, the evidence in this case will show that the one person responsible for this entire accident is the same person who seeks money damages. Well, the evidence in this case will show you that Mr. Stryker is not entitled to any money damages. Not at all. And at the end of this case, we will get back up and we will talk to you in our summation. And when I'm done with that, I will ask that you go back and that you deliver it. And that consistent with the evidence and your oath as jurors, that you return a verdict for Midtown and Avery's. And you tell Mr. Stryker that while you may be very sorry for his injuries and for his accident, it is not anyone else's fault but his. Thank you, ladies and gentlemen. It is 12:40. We're going to come back at 1:45 and we're going to continue with the trial.